Well, good afternoon, ladies and gentlemen, and welcome to our webinar on the new NEC4 suite of contracts. My name is David Rintoul, Head of the Construction Practice here at Clarks Legal, and I am joined for this webinar by my partner, Ruth Wilkinson. We are delighted to be speaking to you all today about the new NEC4 forms of contract, which were published just a few weeks ago on the 22nd of June. In this webinar, we will be covering the key changes that have been made to the NEC4 form as compared to NEC3 and commenting on their practical effect. In this webinar, we'll be covering the following topics. Initially, a brief overview of the overarching considerations behind the changes and new forms of contract. We'll then move on to identify and comment on the key changes and their practical effect, including an introduction to the two new forms of contract, namely the design, build and operate contract and the alliance contract, and then look at new features, new core and secondary options, and we'll also conclude with an overview of other key changes in the context primarily on the energy and construction contract and the changes. We hope at the end of this webinar you'll have a better understanding, therefore, of the nature of the changes and how we think they are likely to affect users in practice. Clearly, only time will tell what the full effect of these changes will be, and we all look forward to seeing NEC4 in operation soon. If I can then turn, please, to the background to the NEC4. As I say, it was released on the 22nd of June, replacing NEC3, which in turn had been in place for some 12 years from 2005. NEC3, I should add, will remain in use on existing projects, and indeed NEC has promised to continue to support that use. In the white paper produced by NEC before the contracts were released, it said that the criteria for the changes it was introducing in the NEC4 are primarily threefold. Firstly, to support the changing requirements of users. Secondly, to better encourage and stimulate good project management. And thirdly, to improve clarity and simplicity, so that NEC4 is therefore designed to develop and update and indeed refresh NEC3. NEC4 largely retains the style, layout, terminology and key project management processes that run through all existing NEC contracts. It's intended, therefore, as an enhancement, or as I've termed it on the slide, an evolution, as opposed to a revolution of the NEC3 contract. So it retains the philosophy behind the NEC suite of contracts, namely risk sharing and collaboration between the contractor and the employer, as well as effective project management. Whilst there are many reasons behind the changes, there are, I think, four factors that predominate. Firstly, industry feedback. In preparing NEC4, NEC engaged with over 400 companies within the NEC3 users group to obtain their opinions as to how the NEC suite of contracts should be updated and enhanced. Secondly, and part and parcel with that consultation, was identified the clear need to reduce the number of Z clauses or amendments typically in use with the NEC3, and which has led on occasion to considerable alteration of the inherent risk profiles, whilst also causing inconsistency and ambiguities which affected in turn the administration of the contract, whilst also conflicting with core NEC3 principles. For example, one would often see the spirit of mutual trust and cooperation clause deleted. The third driver for change was to reflect current industry and best practice, to include, for example, greater implementation of BIM, the design and build contract, and the subsequent introduction of the Bribery Act 2010, and finally to promote greater global use of NEC suite of contracts and so compete with FIDIC, and indeed part of the rationale for the introduction of the Design, Build and Operate, and as we will see, the new Dispute Avoidance Board provisions is entirely for that reason. It should, in summary and closing on this slide, just be noted, however, that many of the changes are optional, and so it's intended that the contract fully retains its inherent flexibility for use as users decide is best suited to a particular project. Moving on to the NEC4 contract suite slide, the entire contract suite I've listed on that slide comprises those new and updated suites of contracts. Most of the changes to the engineering and construction contract that we're focusing on in this webinar apply equally to all suites of contracts. It's to be noted that the new dispute resolution service contract that I list on that slide replaces the adjudicator's contract under NEC3, and the NEC4 alliance contract that I also list at the bottom there has initially been issued in consultative version only. It's not yet been formally introduced to allow in the meantime for industry feedback and final amendment before issue. By way of overview, therefore, I've tried to present on this slide an overview of the key changes on this one page. The revised core and secondary options have been changed, secondary options being the X clauses to be selected in the contract data part 1, and the intention behind these revisions is to reduce the volume of Z clauses, as I've previously highlighted, being a key driver behind the changes. I've mentioned on the slide compensation events, and there have been two key changes to the regime that we'll touch on in some more detail later, but in introduction now, a contractor can now recover costs of a quotation, whereas previously this was not possible, and I think that's a very sensible change. And secondly, project-specific compensation events can be included at contract data part 1, so again reducing use of Z clauses. The contract incorporates additional core clauses such as confidentiality, assignment of contract benefits, and secondary options now introduced include early contractor involvement, and again the aim behind that is to try to identify and resolve problems and risks much earlier than historically has been the case, together with use of BIM and collateral warranty incorporation, with agreed forms to be included in the scope of contract, and both incorporated via use of X options. If I can then turn to the Design, Build and Operate contract that has now been introduced. This contract intends to combine the procurement of usually disparate functions of design, construction, operation and maintenance together from a single supplier. The focus being on the operation of existing and new assets, with the design and build being the enabling part of that overall function. It also allows for straightforward facilities management type services to be performed and incorporated within it, and so provides an opportunity for clients, therefore, to procure an integrated whole life delivery solution for their projects, both before, during and after engineering and construction works are completed. I think the spirit of this is very much in line with the industry move to embrace soft landings, both by government projects and indeed private projects, whereby designers and constructors remain involved with projects at least 3 years after the completion of construction to ensure a smoother handover to the operator, and indeed to ensure that the operator's requirements are taken into account much earlier in the initial design process than is typically the case hitherto. The contract further recognises greater involvement, input and responsibility of the contractor during the operational phase, with payment being split into Part A, allowing for construction as a series of lump sums and service as periodic payments, together with Part B, which allows for target share by reference to pre-agreed performance tables. Two practical issues that I've just highlighted on the slide I'd like to draw to your attention. The contract does not allow for or include any provisions for the contractor to fund the construction of the project, and question marks, I think, remain over whether in practice it will be a viable alternative to the more established FIDIC Gold Book form of contract, that is design, build, finance and operate, and only time will tell, but that certainly is the intention. If I can then move on to the second new form of contract now introduced, namely the alliance contract. This alliance contract has been, as I said earlier in the introduction, produced only in consultation form by the NEC. It's currently intended that the consultation process will end and the contract be published in final form in sometime in 2018. The alliance contract as a concept is quite a radical change for NEC, as it introduces multi-party contracting to the suite for the first time. The ethos behind the contract being to incentivise and reward project participants by reference to success or failure of the project as a whole, rather than focusing on individual performance. So in essence, therefore, it's a new form of partnering contract and has been produced in response to client demand with the aims of supporting clients' intentions to fully integrate a multi-party delivery team for large, complex projects. This is consistent with the report published by the UK's government advisory body Infrastructure UK in 2015, which set out a business case for using alliance as a procurement route because it was said to deliver increased efficiency through behavioural and cultural changes. Whilst the NEC contracts generally allow for all members of the supply chain to be engaged on similar terms and conditions, they are usually, of course, bi-party arrangements. As such, historically, NEC contracts have been transformed into an alliance arrangement using secondary options such as option X12. And so the alliance contract, now published in consultative form, is a response to the NEC users who preferred previously, historically, a single form of contract for alliancing to allow all parties to enter into the contract under the same terms and conditions. And whilst the alliance contract adopts the same principles and structures as other NEC contracts, it does incorporate this integrated risk and reward model. A couple of key features include the management of the alliance contract by an alliance board, the alliance manager carrying out the role essentially of the project manager, and is intended to be concluded on a cost reimbursable basis, i.e. defined cost plus fee, similar to option E. The alliance board will be responsible for resolving disputes, and whilst there's no reference to formal dispute resolution process by adjudication, etc., nonetheless, clearly, if the contract is caught by the provisions of the Housing Grants Act as a UK domestic contract, then adjudication under the scheme will apply if not allowed for under contract. The contract uses a single contract data for all parties, created by mutual agreement, with payments made into a project bank account. The NEC have taken this opportunity in renewing and updating their contracts to introduce some new terminology. This, and I've set out on the slide some of the routine and most important changes in definitions and terms as between NEC3 and NEC4 by way of overview of the key changes. The main theme to these changes is an evolution, so that they represent an update or adjustments to approach and terminology, as opposed to any more fundamental change. You'll see that employers being replaced by the term client, the term client being more commonly used in other standard form of contracts in the industry. The secondary option X12 has changed from partnering to multi-party collaboration to better reflect the intent and philosophy of the NEC. Secondary option X4, parent company guarantees, now been renamed Ultimate Holding Guarantee, and I should add contains additional detailed provisions for the guarantee to be given by an intermediate company. These new provisions recognise the existence one typically sees of more complex corporate structures, and the client may require a guarantee from an intermediate holding company if the client is satisfied with its financial strength, reflecting the approach commonly adopted on major projects. The term scope has been introduced to replace work, goods, service information, so describing the remits of the work to be provided by the contractor to the client. This scope will include the requirements of the contract so as to ensure consistency between the two. The current term used by NEC3 of risk register has now been renamed early warning register under NEC4. In so doing, NEC acknowledged that this will help users to distinguish this from the project risk register, which is used very often for wider project management purposes. Many users having complained to the NEC that they were confused by reference to the risk register with other similar documents of similar name that the employer/client ought ordinarily to use. And finally, NEC4 contracts are now gender neutral in use of the term it or its as opposed to he or his, etc. The NEC saying that this is a simple but important improvement. Turning then to the programme, clauses 31 and 32, there are two key changes to identify here by way of key features. Firstly, that NEC4 now provides a mechanism for treated acceptance or deemed acceptance of the contractor's programme if the project manager fails to respond to an issued programme for acceptance or fails to respond to a reminder. The contractor must give the project manager a reminder, and if he doesn't reply to that notice, then the programme is deemed to be the accepted programme. And secondly, the requirement in clause 32 to show implemented compensation events in the contractor's revised programme has now been removed from NEC4. This is because there was no specific reference to what should be done in regards to compensation events that had not been implemented, so it was thought better not to cloud the issue. And so the practical effect of these changes is in relation to the deeming provision, so reducing the number of non-accepted programmes. The NEC and compensation event process are reliant, as you know, on an up-to-date process being implemented, and so it's hoped that this will increase the pressure to collaborate to agree changes to the programme promptly and efficiently. However, some commentators are already querying whether or not this could affect the quality of programs in the event that a project manager doesn't respond to a reminder, and so the contractor's program stands by default as the accepted program. Equally, does the 2-week period give the project manager enough time to review and consider the program submitted by the contractor, particularly if he is worried about taking on liability? He may, for example, be unsatisfied with the contractor's planned completion date being pushed beyond the actual completion date, or equally where the contractor's program may be non-compliant with other works information. The changes to clause 32.1 will make it clear that the program should show the effect of both implemented and non-implemented compensation events. The NEC having confirmed that omitting non-implemented compensation events is not the intention behind the drafting in NEC4. If I can then turn to contractors' proposals, clauses 16 and 36. The NEC4 suite of contracts now include processes for contractors to propose changes to the scope of the works to allow for cost reduction opportunities. But both the project manager and the contractor can propose positive changes to improve the project outcome, especially where these arise during the course of the works, which may not have been obvious at the start. The contractor can also, pursuant to clause 36, propose an acceleration in order to achieve early completion before the actual completion date. However, there are no changes in terms of the process for quotation and acceptance or rejection of that acceleration proposal. The contractor has also been provided with a mechanism to propose changes to the scope of the contract to allow for cost reduction, so reducing the cost of an asset over its whole life. That's option X21. So these mechanisms therefore encourage value engineering, the contractor being obliged to mitigate delay, but it is otherwise not obliged to accelerate. Additionally, both parties now have a procedure whereby either of them may identify opportunities to allow joint discussion under the framework or other partnering arrangement, with a contractor getting to share in the cost savings of any opportunities that it may initiate. This should therefore help to improve overall project outcome and lower at least out-term build cost and time. It's to be seen as an incentive to the contractor to encourage proactivity and innovation in identifying opportunities for cost savings throughout the project. I'd then like to turn to enhanced and alternative dispute resolution mechanisms. As I said in introduction, the NEC4 have now introduced the dispute resolution service contract in place of the NEC3 adjudicators contract, and so includes new processes to help parties avoid time and costs typically associated with formal dispute process. It also provides a different process for appointment of dispute resolution services. The NEC4 dispute resolution service contract is not restricted simply to the appointment of an adjudicator. The contract will address other forms of dispute resolution outside of adjudication and try to reflect the range of dispute avoidance and resolution mechanisms which major projects worldwide tend to take advantage of. So, for example, the procedures allow for and provide for a 4-week period of escalating and negotiating disputes before moving into formal proceedings is allowed. Options W1 and W2 under NEC4 also include the option to refer disputes to a senior representative of the parties prior to and appointment of an adjudicator. And this is mandatory where dispute resolution W1 is said to apply. So this is most likely to be relevant in international projects, for example, in the absence of applicability of the Housing Grants Construction and Regeneration Act 1996, that of course introduced and pursuant to which adjudication is undertaken. The dispute resolution option can be consensual if option W2 applies, and this applies equally where the contract may be subject to and the parties have the right to adjudicate. There's a new option W3 that provides for the use of a dispute resolution or avoidance board to be used as an alternative to adjudication. This is similar to the dispute avoidance board in FIDIC contracts and will likewise tend to apply primarily to projects outside the UK. Parties may refer disputes to the dispute avoidance board, who are nominated by the parties and agreed at contract formation. As I said earlier, the adjudicator's contract has been changed so that it can be used to appoint board members, and it's been renamed the Dispute Resolution Service Contract. Under this, the client, contractor and project manager appoint a representative who will make up the dispute avoidance board. That board is empowered to visit the site and be familiar with the project from the outset, making recommendations and proposed solutions in order to resolve disputes. Parties are free to reject or accept the recommendation of the Dispute Avoidance Board, and if they disagree, can then proceed with, for example, adjudication if necessary. The contract encourages consensual resolution of disputes. No formal dispute resolution proceedings can be instigated unless the parties reject the recommendation of the Dispute Avoidance Board. Whilst W3, which provides for use of a Dispute Avoidance Board, is not intended for use when the Housing Grants Act applies, if the process was consensual, rather like the escalation wording in option W2, then it could equally possibly apply when adjudication is an option to the parties as well. Right, I'll now hand over to my partner Ruth, who will take you through to the conclusion of this webinar. Thank you.
Thank you, David. I'll continue to look briefly at some of the new features to the suite and also new core and secondary options. First, I'll look at payment and the changes to core clause 50. There are three key changes to the payment provisions. These are intended to keep cash flowing and bring certainty to the process. The first change relates to the interim payment process. In NEC4, the contractor is now required to submit an application for payment to the project manager before each assessment date. The application for payment sets out the amount the contractor considers is due at the assessment date. If the contractor fails to issue an application for payment, then the amount due is the lesser of the amount the project manager assesses as due and the amount due at the previous assessment date. This brings NEC4 in line with what happens in reality in the industry. The second change relates to defined cost, which forms with the fee the basis of the price for work done to date in the cost reimbursable contracts, so option C, D, E and F. Under these options, the contractor is obliged to provide cost forecasts of defined cost at intervals specified in the contract. The definition of defined cost depends on which option. For option C, D and E, it is the cost of the components in the schedule of cost components, less disallowed cost. The contractor is also obliged to keep records of defined cost incurred and to make them available to the project manager for inspection on request. This process is consistent with the NEC philosophy of proactive risk management and is in order to avoid any nasty surprises. In NEC4, there is a new process to allow the contractor to request that the project manager reviews the contractor's assessment of the defined cost. The project manager is required to review them within 13 weeks, and communicate his acceptance or otherwise advise of any errors identified. The project manager is sanctioned for non-compliance. Failure to review means that the defined and disallowed costs of the contractor are treated as accepted. This should encourage the parties to assess costs regularly rather than at the end of the project, and thus eliminate disputes associated with final accounts. The professional services, term service and supply contracts have been amended such that they use defined cost in the same way as the engineering and construction contract, allowing for a common approach across the suite of contracts. The third change is that NEC4 introduces a new final accounts process to reach agreement on final amounts due under the contract. Traditionally, the NEC approach has been that since costs and compensation events are required to be assessed in real time, there was no need for a final accounts process. This new process provides users the benefit of a mechanism that gives finality to costs and avoids subsequent challenges. NEC4 provides an obligation on the project manager to issue a final certificate of the amount due, either after completion of the contractor's obligations under the contract or upon termination of the contract. This introduces rigorous timescales. The project manager must issue the assessment within 4 weeks of the defect certificate or 13 weeks of the termination certificate. Failure to do so means that the contractor is allowed to submit his own assessment. This is similar to the provision in the JCT contracts, and the client pays for it if they are in agreement with it. The final assessment will be conclusive of the final amount due if it remains unchallenged, unless either party invokes the dispute resolution provisions within a specified timescale. Where they do not agree, the parties will enter into discussions with senior representatives from both sides and then proceed to adjudication or the courts if they fail to settle the dispute. Looking next at compensation events. 2 new compensation events, as David said earlier, have been introduced via clause 60.1. The first is a new compensation event, whereby if the project manager notifies the contractor that it has not accepted its quotation for a proposed instruction, the contractor is reimbursed for the cost of preparing the quotation. This compensates the contractor for the cost of preparing a quotation for changes to scope and proposed instructions not subsequently adopted by the project manager, and this is in clause 60.1.20. This ensures that the employer client does not benefit from requesting numerous quotations for proposed instructions and then failing to accept them all. The second compensation event is a DIY or a do-it-yourself compensation event, and it's in clause 60.1.21. The effect of this is that the parties are able to agree and introduce additional compensation events into Part 1 of the contract data. This is instead of using the Z clauses to incorporate additional ones. Essentially, the client can alter the standard risk profile without using Z clauses. For the purposes of assessing the effect of compensation events, there is also the introduction of a dividing date principle, whereby for compensation events arising from the project manager or supervisor, the dividing date is the date of the original communication. And for other compensation events, the dividing date is the date of notification of the compensation event. The purpose of the dividing date is to ensure that assessments will usually be forecasts of the work yet to be done and not retrospective. It is also stated that the delay should be assessed by reference to the accepted programme current at the dividing date. Assessing delay is often a complex process, and the dividing date principle, although directed at trying to provide clarity, could cause issues which may need guidance and/or expert input. For example, what if a contractor takes 8 weeks to notify a compensation event, and in the meantime there has been more than one accepted programme, which itself shows the effect of that compensation event? So moving from compensation events to the schedules of cost components. The schedule of cost components is a list of allowable costs for which the contractor is entitled to payment. It is used for assessing compensation events and interim payment. The schedule of cost components has been revised and simplified, and one of these changes is changes to the fee. There is now only one fee percentage, and NEC4 eliminates the separate fee percentages for 1. Subcontracted works and 2. Direct fee percentage. The feedback from users was that having different fee percentages was unnecessary. The short schedule of cost components has been removed from main options C, D and E and now used exclusively in options A and B only to assess compensation events. However, the schedule of cost components will now be used only for main options C, D and E. We would expect that quantity surveyors will need to work through these changes carefully to avoid being caught out. Moving now to look at core options. The first core option I'll look at is bribery and corruption. NEC4 includes a new provision to deal with corrupt acts. This is Core Clause 18. This clause does three things. The clause prohibits corrupt acts, it requires the contractor to take positive steps to stop a corrupt act of a supplier or subcontractor, and thirdly, it provides for termination of the contract where such acts arise. The provision reflects the provisions of the Bribery Act 2010 and considers the safeguards usually required by clients in other forms of standard form contract in the industry, and thus eliminates the need for Z-clause amendments to incorporate anti-bribery clauses. However, NEC4 fails to expressly cover new legislation, for example the Modern Slavery Act of 2015 and the Public Contracts Regulations of 2015, which require the supply chain to be paid within 30 days as required under public sector contracts. From bribery to disclosure. In NEC3, confidentiality provisions previously appeared only in the professional services contract, but are now included in all NEC4 contracts, except the short ones. In ECC, this is Core Clause 29. The wording mirrors the usual requirements for confidentiality and non-disclosure. This is seen to encourage best practice, as confidentiality clauses are commonly seen in most other forms of standard contract, and again, this eliminates the need for Z-clause amendments. Now to assignment. The parties are now expressly permitted to assign the benefit of the contract. This is Core Clause 28. Note that this allows either party to transfer the benefit of the contract, but they cannot transfer the burden. Under English law, this can only be done by way of novation. The assignment provision maintains the spirit of mutual trust and cooperation, which is now in Clause 10.2. We would note that Clause 10.1, as it was, has now been separated into two clauses. However, NEC have said this will not change the effect of the provision. The client cannot transfer the benefit of the contract to an assignee who does not intend to act in the spirit of mutual trust and cooperation, thereby reflecting the NEC philosophy. It's not clear why this doesn't apply equally to the contractor. After a quick run through of the key features, I will now look at the new secondary options introduced by NEC4. As I'm sure you all know, the secondary options have to be specifically selected and referred to in the contract data. I'll deal first with design and build option. In the NEC, there is no design and build form, so parties use the works information to allocate design responsibility to the contractor. NEC3 does not expressly deal with the standard of care in relation to design, meaning under English law the contractor is subject to an absolute fitness for purpose obligation unless option X15 is selected. Option X15 refers to reasonable skill and care to ensure design complies with works information. Therefore, NEC3 was often amended by way of Z-clause to deal with duty of care and add more familiar drafting, for example, the duty of skill and care used by a designer designing similar works, etc. In NEC4, a new secondary option supporting design and build contracting has been introduced. New option X15 includes the following three features. First, the contractor's design duty is aligned with industry standard as preferred by insurers. For example, the contractor's standard of skill and care of design is that of professionals designing similar works. Second, there is an obligation on the contractor to maintain PI insurance. This is intended to deal with the requirement for contractors to provide professional indemnity insurance standards of skill and care and IP licenses that users previously had to incorporate using the Z clauses. Thirdly, it also deals with issues relating to the retention of documents in relation to design information. Again, this is a preference of insurers who frequently required contracts to define retention of documents. As this now aligns with industry standards, parties may see less need for Z clauses. Moving on then to early contractor involvement. Secondary option X22 under the NEC4 engineering construction contract directly incorporates the ECI clauses previously published by the NEC in November 2015. This amends the contract to allow for two-stage contracting. The rationale behind early contractor involvement is that it is easier for improvements and innovations to be introduced at the early stages if the contractor is involved. It's also a powerful tool to facilitate collaboration and partnering, and the option is only for use with options C and E. NEC4 also introduces a secondary option X10 to support the use of BIM and the management of BIM requirements, including ownership of information and liabilities of the parties. NEC had previously produced some standalone clauses for incorporation in NEC3. It is referred to as information modelling, but this is just a matter of terminology, perhaps to reflect that NEC covers more than just buildings. The contractor is required to provide an information model execution plan to be incorporated in the contract either from the outset or within a defined period by the client. This will be in line with the BIM requirements of the client. This should reduce the need for Z clauses and recognises the increasing use of BIM, which is being driven by government policy. JCT, we should note, has also published provisions dealing with BIM in its 2016 form. Next, we deal with collateral warranties. NEC4 also includes a secondary option, option X8, to allow for the provision of collateral warranties to third parties from contractors and subcontractors, which users previously had to incorporate using the Z clauses. This collateral warranty option was previously only available in the professional services contract under NEC3 as a secondary option. The reference on the slide to option Y, which incorporates the Third Party Rights Act, which is not new, is merely there to note that the industry has not embraced widely using third-party rights rather than warranties. The continued use of collateral warranties is in line with market practice both internationally and domestically, and this amendment should avoid the need for Z clauses. However, no form of warranty is provided by NEC, so that will need to be prepared by the parties. Finally, I just wanted to have a quick overview of some of the other changes that we've identified. It's not possible to capture all the changes in this talk, and more will no doubt come to light as people get to grips with the contract and using it in practice. However, we will highlight a few of these changes that we think you should be aware of. So firstly, secondary option X16.3, which deals with retention, now includes an optional provision to provide a retention bond rather than the retention of money or cash. The terms risks and indemnity in section 8 under NEC3 has been changed to liabilities and insurance. This change has come about because 1. Risk has a different meaning ascribed to it elsewhere in the suite of contracts, and secondly, the term indemnity is not well understood outside the United Kingdom. This is as a result of response to concerns by insurance experts and the industry for the NEC to clarify the intent of Section 8. In NEC3, it provided that the contractor's risks were all those that were not the employer risks, so effectively a catch-all provision. This has been changed in NEC4, so the contractor's risks are identified in Clause 81.1. Clause 17.1, which deals with how to resolve ambiguities or inconsistencies, has also changed, so it now requires that the project manager should state how the ambiguity or inconsistency should be resolved, rather than instruct it. This may cause conflict because the project manager can wriggle his way out of instructing a decision, as it gives him total power to state how the ambiguity is to be resolved rather than to instruct. There is a new quality management regime in Clause 40, which had been included in the Professional Skills, the PSC. Finally, there is a new termination at will procedure at secondary option X11. In effect, if the client terminates at will, the contractor is paid its fee on the outstanding balance of the work. So, in conclusion, we've had a quick tour of the changes and have tried our best to highlight the practical effects of these. Based on our review, we agree that NEC4 is an evolution, not a revolution. It reflects the NEC's willingness to incorporate direct industry and user feedback by addressing issues such as the allocation of risks common in engineering and construction contracts. It's made changes to reflect developments such as BIM and the Bribery Act, and in the main, the changes made are welcome ones. As discussed over the course of this webinar, it's hoped that many of these changes will reduce the need for the incorporation of multiple Z clauses. although no doubt these will continue to be used to some extent to accommodate specific project requirements. However, NEC3 remains relevant for the foreseeable future and will continue to be valid and enforceable and supported by NEC. For example, High Speed 2 is being undertaken under NEC3 and has a significant duration for delivery. Many contractors and clients undertaking projects using the NEC3 contracts, which are at tender stage or beyond, will aim to see their projects through to completion. NEC4 can now be used on new projects, and its new provisions such as bribery and BIM can be incorporated into NEC3 using the Z clauses. As part of the objective was to widen its international scope and the introduction of the DBO form of contract and also the Dispute Avoidance Board. However, it remains to be seen whether this will be taken up as an alternative to FIDIC in the international sphere. In any event, there is a philosophical difference between NEC and FIDIC principles. So it remains to be seen what the real practical effects of NEC4 are, if any, as the new contracts begin to be used industry-wide.